Hi, everyone, and thank you so much for joining us today for our webinar, Immigrant Access to Benefits in 2021, a Policy Update. My name is Isabel Moyadeen, and I'll be running the tech side of things today, but I'll also be giving a brief intro for our presentation before passing things off to my colleagues, Gabrielle Lassard and Catherine Lundy. So to kick things off, I'm just going to tell you a little bit about us here at the National Immigration Law Center. Established in 1979, NILC is one of the leading organizations in the country exclusively dedicated to defending and advancing the rights and opportunities of low-income immigrants and their family members. Just a quick disclaimer, though, we are not immigration attorneys, and nothing presented today or in any of our webinars should be presented or taken as legal advice. And this is actually the last webinar in NILC's training series. We've been running this webinar series for about a year now, and each webinar has been recorded and all the slides have been uploaded onto a virtual training library. I'll be sending out a follow-up email shortly after our webinar ends today with some more information on how to access that site, along with the password that you'll need to get on. So no need to try to jot down anything on this slide here. You'll have all of it for reference soon. And before we kick things off, I'm just going to run us through a brief roadmap of today's webinar. We're going to be starting off with a breakdown of the major public charge news from just a few weeks ago. You'll get a brief refresher on what public charge is, what the changes to public charge look like from 2020 to where we are now in 2021. And finally, we'll be sharing some important messages for providers and clients. Then we're going to review some materials created specifically for eligibility workers and consumers. And then we're going to walk through some potential immigration law changes. We should have some time at the end of the webinar for a quick Q&A, so feel free to send in your questions throughout the webinar. No need to wait until we get to the end. And with that, I'm going to pass things over to Kat to walk us through a refresher on public charge.
Thank you so much, Isabel. Hi, everyone. My name is Kat Lundy. I'm a state and local policy analyst at the National Immigration Law Center. And for this section, I'm just going to give a brief overview of what public charge is, just so that we're all familiar with the foundations of this policy. Next slide is where we're going to be talking about what the definition of public charge is. So the basic definition of public charge is a person who is primarily dependent on the government for support. Next slide. We're going over a brief history of the public charge policy. So public charge has been a part of federal immigration law since 1882, but has historically been very limited in scope in how it is applied. In 2019, the previous administration instructed the Department of Homeland Security, DHS, to publish regulations that expanded the meaning and application of public charge. So instead of being what it had always historically been, which was very limited in scope, this 2019 regulation would have expanded the number of programs and broadened who public charge could apply to. The current administration has allowed the courts to block that 2019 DHS rule. So the recent changes you may have heard about in the past couple of years have been blocked and are not in effect. Next slide. Public charge policy comes up across 3 separate agencies in the U.S. government. So it comes up for the Department of State, the Department of Homeland Security, as well as the Department of Justice. So in the State Department, public charge policies will be applied to applications for visas or green cards that are processed outside of the United States. So that's done through consular offices around the world. The public charge policies that are under DHS are for applicants or for applications that are being processed inside the United States. And then the Department of Justice has public charge policies that apply to people who have already been admitted to the United States. Next slide. So how is a public charge inadmissibility, or how is the public charge test sort of conducted, and what do they look at? So a public charge assessment allows the U.S. government to deny immigrants a green card or admission into the country if they are likely to become a public charge in the future. So DHS makes this determination on a bunch of different factors, like you can see age, health, family status, or the number of people that you might support, education and skills. Did you go to school? Do you have a diploma? Employment, do you work? Where do you work? as well as an affidavit of support or a contract that an immigrant makes with their sponsor. No individual one of these factors can be used to determine whether or not someone is a public charge. Like we said, it is a holistic test that looks at all of these different things. Next slide. And who does public charge apply to? Public charge primarily affects family-based immigrants. Public charge test is not applied to every single immigrant or every single application, and many categories of immigrants are exempt from a public charge test. So this would include refugees and asylees, self-petitioners under the Violence Against Women Act, people that are applying for or have U or T visas, people that have been granted SIJS, also known as the Special Immigrant Juvenile Status, and there are many more exemptions to those where public charge does not apply. So the link you see here in the slide, while it is attached to the 2019 rule, we want to say that this is actually, unfortunately, the most comprehensive list of all of the people that public charge does not apply to. And NELC is currently working to make sure that there is another aggregated list somewhere else, and it is most likely going to be in whatever the new rulemaking is for the public charge test in the future. Next slide. So when does the public charge test apply? Public charge assessment, this test is only made when a person is applying to enter the United States, is applying to adjust their status to become a lawful permanent resident, also known as an LPR. You may also know this as getting your green card. And it also applies to a green card holder when they leave the US for more than 180 consecutive days or 6 months and then try to re-enter. One of the things that when you receive your green card is you're sort of making a promise with the US government that you do plan to stay in the United States for the long term. This 180-day rule is for folks that have left for a long period of time. When you come back in and re-enter the United States, you have to go through that assessment all over again. Okay, and then public charge, again, does not apply to a lot of different applications. For example, public charge does not apply when someone applies to become a US citizen or naturalizes. It does not apply when someone is renewing their green card. And it does not apply to have the conditions removed from a marriage-based green card. And for the next section, I'm going to kick it over to Gabrielle to talk a little bit more about how the public charge policy changed in 2020 and 2021.
Thanks, Kat. Next slide, please. So we talk about the 2019 public charge rule because that is actually when the final rule was published in August of 2019. However, because of litigation, the rule did not actually go into effect until February of 2020. So the Department of Homeland Security public charge rule that was finalized in 2019 really made 3 major changes to the way public charge was assessed and defined. So first of all, instead of the substantially dependent on the government for subsistence definition that Kat led with, which has been historically in use since the 1800s, it created a new definition that based the determination of public charge status on whether a person had used a certain threshold amount of public benefits over a 3-year period. It then took that totality of circumstances test that was illustrated by all the little rectangles, and it added a number of factors to each of those elements, including income thresholds that made it harder for low and moderate income people to have a successful outcome in a public charge assessment. And then it also added a number of public benefit programs that would be considered by immigration officials in determining whether somebody was likely to become a public charge in the future. So these included things like CalFresh and non-emergency Medi-Cal for adults, which, you know, again, the assessment would be based on whether the person was expected to use those, in addition to whether they had actually used them at any time in the past. Next slide. So even before the rule went into effect, it stopped people in immigrant families from getting benefits for which they were eligible. More than 1 in 7 adults in immigrant families reported in an Urban Institute study that they or a family member had avoided a non-cash benefit program such as Medi-Cal, CHIP, or SNAP, CalFresh in California, because they were worried about their ability to get a green card in the future. Among low-income families, over a quarter of adults reported that they had experienced this chilling effect. Next slide. So a lot happened between 2019 and 2021. So again, the final rule was published in August 2019. Immediately, there were at least 11 different legal challenges filed. The original effective date for the rule was October 15th of 2019, but there were on that date a number of court orders that prevented it from going into effect. By February 24th of 2020, enough of those orders had been resolved that the rule was able to go into effect. In October of 2020, the government asked the Supreme Court to take the pending public charge cases. In November, a federal district court in Illinois issued an order that vacated the rule. So that basically means that it canceled the rule. But then the Seventh Circuit Court of Appeals put it on hold because the case was pending before the Supreme Court. As you all know, in November of 2020, there was also the election. Next slide. So in January 2021, we had the inauguration. On the date of the inauguration, President Biden signed a number of executive orders touching on immigration and other issues. But it actually wasn't until February that the president issued an executive order related to public charge. And this order directed the different agencies that Kat showed on her slide, as well as the benefits granting federal agencies, to review all of their public charge policies and to report back to the president in 60 days. In March, while that 60-day period was still pending, the government petitioned the Supreme Court to withdraw its appeals of the public charge cases. The Supreme Court allowed the administration to withdraw those appeals, and then the Seventh Circuit Court of Appeals dismisses the order that it had issued that blocked the lower court's order vacating the rule. So that allowed the decision vacating the rule to go into effect. At that point, the public charge rule was canceled everywhere in the country. And the Department of Homeland Security, and specifically US Citizenship and Immigration Services, announced that the public charge guidance that was issued in 1999 would apply. What's next is that the 60-day period for the agencies to report back to the president is going to end on April 3rd. Next slide. So on March 15th, USCIS, US Citizenship and Immigration Services, published regulations that were effective on March 9th, which was the date that court order that canceled the rule nationally went into effect. And those regulations removed the regulations that were published or that were finalized in August of 2019. And it discontinued the Form I-944, Declaration of Self-Sufficiency, which was an extremely burdensome form that people had to fill out to show that they weren't going to become a public charge, as well as other forms that were used to implement the 2019 regulations. And on the bottom of this slide, there's a link to that publication in the Federal Register. Next slide. Also effective March 9th, but not published until March 15th, USCIS issued a notice that it was no longer applying the 2019 public charge rule, and that as a consequence, among other changes, it was going to apply the public charge inadmissibility rules in the way that was spelled out in a 2019 interim field guidance that was published by the Immigration and Naturalization Service, which was the predecessor to the Department of Homeland Security. That notice also said that the applicants and petitioners should not provide, and those are people who are either petitioning for a relative, as well as people who are applying for green cards for themselves, should not provide any information or evidence that is related solely to the 2019 public charge rule. So that means that people who were applying for adjustment of status to become lawful permanent residents should not submit the form I-944 or any evidence or documentation required by the I-944, including in cases where people had submitted their applications prior to March 9th, had included the I-944, and then had a request for additional evidence. They did not need to respond to that request as long as it was related solely to the 2019 rule. Next slide. Okay, so what's in the 2019 field guidance? And we have a poll. Isabel, can you put, there it is. Okay, why is there a picture of Prince on this slide? Because he was from Minnesota? Because we are wearing raspberry berets? Or because we're going to party like it's 1999? Okay, let's go to the results. Okay, 22% of you said because he was from Minnesota, which is definitely on our minds right now. But the answer is because we're going to party like it's 1999. Next slide, please. Okay, so first of all, the 1999 field guidance was developed as a result of people's reactions to laws that were passed in 1996. People who, like myself, who were around then, remember that 1996 was the year of the Contract with America and welfare reform. And those laws restricted immigrants' eligibility for benefits, as well as codifying existing policies on public charge. So it was actually in 1996 where those different factors like age, health, family status, etc., were first put into law, although they had been long-standing policies. Some state agencies thought that the 1996 laws required them to require immigrants to repay the cost of benefits that they had received. This is something that did happen in California. As a result of fears about the combination of the eligibility restrictions and the more detailed definition of public charge, immigrant families were avoiding health care and other public benefits. And there was, like now, a communicable disease outbreak, which was measles. So the Immigration and Naturalization Service, working with advocates, developed the 1999 field guidance to clarify the meaning and scope of public charge and to hopefully diminish some of people's avoidance of benefits. Next slide. So the 1999 guidance does incorporate that totality of circumstances test. Those different factors, they are again in the law, so they really needed to incorporate that. So again, the totality of circumstances is just a fancy lawyer way of saying all of the facts. And immigration officials will look at a person's current characteristics and circumstances to determine whether they are likely to become a public charge in the future. No single factor can determine whether a person is likely to become a public charge. If somebody has a negative factor, then that can be offset by positive factors. So it's really a balancing test. Next slide. And then in terms of how that totality of circumstances is applied, the guidance incorporated a quote from the Attorney General at that time, who said that some specific circumstances, such as mental or physical disability, yes, this is discriminatory, advanced age, or other fact reasonably tending to show that the burden of supporting the intending immigrant is likely to be cast on the public must be presented. A healthy person in the prime of life cannot ordinarily be considered likely to become a public charge, especially where they have friends or relatives in the US who have indicated their ability and willingness to come to their assistance in case of an emergency. So this is essentially a presumption that a person is not likely to become a public charge. Next slide. In terms of the benefits that would be considered, the 1999 guidance only considered 2 benefits. The guidance limited the consideration of benefits in public charge determinations to cash assistance for income maintenance and institutionalization for long-term care at government expense. Again, even if the person had gotten either of those benefits, that could be outweighed by positive factors. The guidance also provided that people should not be asked to repay the cost of any benefits that they received in order to qualify for admission to the US or adjustment to permanent resident status. Next slide. So cash assistance for income maintenance is not every kind of cash that a person could get. It is evidence of primary dependence on the government for subsistence. Yes, I know that the S in CalWORK should be lowercase. That is assistance intended to pay for a person's ongoing living expenses, including CalWORKs, CAPE, SSI, or in counties that have it, general assistance or relief. It does not include cash payments that are earned, like Social Security retirement benefits or government pensions, and it does not include special purpose or supplemental benefits such as home energy assistance programs like LIHEAP or child care subsidies. Next slide. And then long-term care is something like a nursing home that a person is residing in for duration that is paid for by Medi-Cal, or public residential facilities such as state homes for people with severe mental illness. It does not include short periods of institutionalization for rehabilitation purposes. So currently with the pandemic, there are a number of people who are leaving hospitals and going into step-down facilities for ongoing rehabilitation from their illness. That is not something that would be considered long-term care for public charge purposes. Next slide. Okay, now I'm going to turn it back over to Kat, who's going to talk about some of the messages and resources that we've developed.
Thanks, Gabrielle. Before I go into the next slide, I just want to point out that we have messages for providers specifically, as well as communities, and we're going to be going over both of those. So next slide, please. So the top messages for providers on everything we've shared would be these 3 that you see right here. First, that the public charge inadmissibility test does not apply to all immigrants, that many immigrants are exempt from this public charge test. So that would be number 1. Number 2, most immigrants that are subject to the public charge test are not eligible for the benefits that count under the test, and many benefits are not considered in the public charge assessment at all. Number 3, we would encourage providers to encourage clients to learn more about their situation given these new changes in policy. Again, there are many public programs that are not considered in a public charge assessment, and there are many immigrants where public charge does not apply. Next slide. So we have created some resources specifically around public charge on in 5 different forms. So number 1, and we have a screenshot here of it, are the ABCs of public charge. A for where it applies and who it applies to. B for what benefits are considered and not considered under the public charge test. And then C, talking a little bit more about the totality of circumstances test, which is that holistic view of an immigrant's application. And like Gabrielle said, totality of circumstances is a fancy word of saying looking at all of the facts. Next, we have a best practices for eligibility workers with working with immigrant families. This is sort of a cultural competency guidelines on how to best practices for interacting with immigrant clients, all of the different particulars of their life experience, and their interactions with government agencies, and some of the things that you should keep in mind when working with those families specifically. We have provided a frequently used documents chart. So for folks that may not understand what an I-944 form is, or what some of these other immigration paperwork forms are, This is also a list to help you understand, like, these are all the other immigration specific paperwork that the immigrant might have questions about, or might be thinking about when they're coming in to apply for or enroll in programs. Number 4 would be an immigrant eligibility for COVID programs. It's a nice little chart for folks to understand what immigrants have access to in terms of COVID support programs. And then finally is just a 1-pager on public charge, something to keep right there at your desk or by your laptop that explains a lot of this too in a very, very succinct way. Next slide. For when you're working with communities, these would be the top things that if you had like an extra couple of minutes and someone was asking questions specifically about public charge, these would be the things that I would highlight. So number 1, letting the community know that public charge does not apply to everyone. Letting them know, number 2, that most public benefits do not impact a person's immigration status. Again, many public programs are not considered in a public charge test. Number 3 is that only a few benefits are considered in a public charge test. So that would be what we've listed earlier: cash assistance that are intended to pay ongoing living expenses like SSI or CalWORKs, as well as long-term institutional care paid for by Medicaid or another government program. The next message I would share is that if you've used these specific programs in the past, the ones that I just listed, you still have a chance to show that you're not likely to become a public charge in the future. Remember, there's the whole totality of circumstances test where they're going to be looking at all factors of a person's life to decide whether or not they would become a public charge in the future. And then the last thing that I would share is that their personal information is protected when applying for public benefits programs, and in only very rare circumstances are they shared with enforcement. Next slide. Okay, I'm going to kick it back over to Gabrielle to talk about some other immigration policy changes that have also taken place and might be important for folks on the webinar. Gabrielle?
Okay, thanks, Kat. And I just wanted to clarify that actually information that a person provides to a benefit program will not be shared with immigration enforcement. Next slide, please. Okay, so I mentioned earlier that the president had executed an executive order. It was on February 2nd, related to public charge. It was actually a broader order about legal immigration, and it opened with a global policy that the federal government should develop welcoming strategies that promote integration, inclusion, and citizenship. Then specifically with regard to public charge, it directed the Secretary of State, the Attorney General, and the Secretary of Homeland Security, and the heads of other relevant agencies, including the benefit granting agencies, to review all agency actions related to public charge, and that the review should be guided by the following principles. The policy set forth in Section 1 of promoting integration, inclusion, and citizenship, addressing concerns about the effect that the public charge policies had on the integrity of the immigration system, as well as on the public health, and communicating the current public charge policies and proposed changes in a manner that reduces fear and confusion. So as you may know or remember, for example, the Department of Homeland Security said that it was not going to consider any health services related to testing and treatment for symptoms of COVID-19 in the public charge test. This was buried in some dense text on their website. They also, outside of the regulations, have not really communicated all of the various exemptions. And it's kind of just up for immigration lawyers to know at what points in time public charge is assessed. So we have been encouraging the Department of Homeland Security to create a consumer-facing FAQ document that really helps people get a better understanding of the limits to the current policies, as well as to develop updated regulations that modernize and improve the 1999 guidance. So again, that executive order required the agency heads to report back in 60 days, and the 60-day period ends on April 3rd. Next slide. On Inauguration Day, the president also issued a number of executive orders, including an executive order on DACA. I think you all know what DACA is. It is the Deferred Action for Childhood Arrival program that allowed people who came to the country while they were children to get 2-year renewable periods of relief from deportation and employment authorization, as long as they met certain educational and background check requirements. So the executive action directed the Department of Homeland Security, in consultation with the Attorney General, to take all actions deemed appropriate to preserve and fortify DACA. So this means that the original DACA program is in full effect. Some of you may have been tracking this during the course of the litigation, where for several years, only people who already had DACA could renew their DACA, but people could not submit initial applications for DACA. So that meant that people who had been too young to get DACA when it was announced in 2012, who were now eligible for the program, were not able to apply. So the original program is back in full effect. In addition to renewing, people can submit initial applications as well as apply for advanced parole, which is a way of waiving any objections to re-entering the country before they leave. This was really important to DACA recipients who were able to go back to their home countries and see, grandparents and other family members for the first time since they were children, because of the availability of advanced parole. Now, there is still an ongoing lawsuit, Texas versus United States. The hearings are actually happening right now, and it is seeking to end the DACA program. So that remains a threat. And we will just have to see what the court does. Next slide. Okay. So in addition to the actions that were taken by the president, there have also been some potential changes to immigration law that have been going through the House. So next slide. Okay, so there was, on the inauguration day, the president announced the outlines of a comprehensive immigration bill called the U.S. Citizenship Act. And on February 18th, this was introduced in the House of Representatives by Representative Linda Sanchez from California, as well as in the Senate by Senator Robert Menendez of New Jersey. And that bill, which is really more of a messaging bill than something that we actually think is going to pass, includes a pathway to citizenship for undocumented immigrants, an accelerated pathway to citizenship for agricultural workers, as well as people who have DACA and people who have temporary protected status, which is a temporary form of relief from deportation that comes with employment authorizations that can be granted to people who are in the United States when something happens in their home country that makes it unsafe to return. There are numerous Central Americans, particularly from El Salvador in California, who have TPS. The bill would also reform our immigration system to prioritize family unity. Some of the major things that it would do in that arena are eliminating the prohibition on re-entering the United States for up to 10 years that is applied to people who have accrued unlawful presence, i.e. been present in an undocumented status in the United States. It would also change the existing system of making people who are not immediate relatives of citizens or who are relatives of lawful permanent residents wait outside the country for, in some cases, many, many years for a visa to become available when their family member petitions for them, and instead allow them to come to the country on a temporary visa while waiting for their relative visa to become available. It would also begin to address the root causes of migration from Central America, including conditioning some financial assistance to Central American countries for certain good governance reforms. And it would replace throughout the immigration law the stigmatizing term alien with non-citizen. Next slide. So we expect that bill to proceed in building blocks, although it's foreseeable that not all of it will be successful. So there is another bill called the Dream and Promise Act. This was passed out of the House on March 18th. You maybe remember that the same bill actually passed the House in 2019, but it was not heard in the Senate because Speaker McConnell did not want to bring it up. So it establishes a pathway to citizenship for DACA recipients and people who would have been eligible for DACA. This was written during the time when only renewals were available, so that will probably be updated, as well as humanitarian immigrants with temporary protected status and a similar kind of relief called deferred enforced departure, which is only available currently to people from Liberia and Venezuela. Next slide. Also passed out of the House on March 18th was the Farm Workforce Modernization Act. So this bill would create temporary residency under a new immigration status called Certified Agricultural Worker Status for undocumented workers, plus their spouses and children, who have performed a threshold amount of agricultural work, which is 6 months over the last 2 years, and who have been continuously present in the US since the date the bill was introduced, have not been convicted in the past of particular crimes, and pass security and law enforcement background checks. The bill would also provide a pathway to lawful permanent resident status, also called a green card, for people who have that certified agricultural worker status and who meet additional requirements for agricultural work, as well as all the other requirements there. The bill would also add employment protections for people with temporary agricultural work visas, including H-2As, which would include things like a right to have shade and drinking water at their workplace. Next slide. Okay, there was one other bill that I wanted to talk about, and I guess we didn't include it, but it was the Essential Workers Protection Act, and it has been introduced but not passed, and it would provide a pathway to citizenship for essential workers. There's a long list of them, but it is defined as including workers in agriculture, food, manufacturing, food production facilities like meat processing, as well as people who work in cleaning and maintenance, and people who work in retail sales and healthcare. So we are done with our presentation, and we'll open it up for questions. Please put your questions in the question box or the chat.
All right, so we've had a couple questions come in so far. Like Gabrielle just said, please feel free to put those questions in when they pop in your head. But we'll get started with these first two. So for Gabrielle, does CalWORks count against caretakers that are only requesting for the child and not themselves?
Yes, any form of cash assistance for income maintenance will count against the family member if it is the family's sole source of support. If let's say that a parent is working in a low-wage job and they are able to receive CalWORks for their child, that child-only case would not count against them. It has to be the only income coming into the household.
All right, thanks, Gabrielle. And then jumping to our second question, Kat, maybe you want to take this one. Are there efforts to get rid of public charge altogether? And how could that happen?
It's a really good question. So I'd say that we've had a whirlwind of events for the past year. So after the March news that the 2019 regulation will not be going into effect, we highly anticipate that the Biden administration will probably undergo its own set of rulemaking to sort of put the 99 guidance or like sort of that as like a benchmark with possible improvements to public charge policy through that notice of proposed rulemaking. To eliminate the public charge assessment altogether, it would have to actually be removed from statutes, which would require Congress and creating legislation to remove it. Gabrielle, would there be anything else you would add about how we would be sort of removing public charge altogether?
No, I think that any amendment to the federal immigration law, which is called the Immigration and Nationality Act, would probably be part of a larger bill related to immigration. The provisions related to public charge are in that law. So we would have to see that amendment. Okay, and then there's a question, will you be sending us the resources for counties, or is that available somewhere? Those are currently being reviewed by CDSS. And once we have finalized resources, in addition to distributing them through CDSS and CWDA, we will post them on the password protection section of the NILC website where the webinars are posted.
I will also add that there are consumer-facing resources around public charge that have been created and updated since the March updates, and those will also be available in, I believe California has either 12 or 16 set languages through HHS. Can't remember if it's 12 or 16, but all of those languages, the consumer resources will be available in all of those languages as well.
Okay, Kat, do you want to take question 4?
Sure. So the only public, this is the question. So the only public charge programs are cash and long-term care paid for by Medicaid or the government. Regular Medi-Cal is not considered. Correct. Regular Medi-Cal is not considered in a public charge assessment, and will not, using it will not impact your immigration status.
Okay, next question, will public charge be limited to a certain time period? We are advocating with the Department of Homeland Security to limit the time period for the prospective public charge assessment to 5 years, which is the time in which a person who has a green card that's not through marriage can first apply to become a citizen. Currently, that has not been defined anywhere. So remember, the public charge assessment is looking at whether the person is likely to become a public charge at some point in the future. Very many of us will eventually end up in long-term care, and for very many of us, that will be paid for by Medi-Cal. So this is one of our big priorities for changes and modernization in the regulation. Okay, we have no other questions. Please input your questions if you have any more. Okay, I think we are done with questions. You all have our emails if something comes up that you think of later, or if you run into a situation with a client and you want to consult with us. But this is, again, the last webinar in our series, and we appreciate everybody for your participation, and we appreciate CDSS for working with us on this project.
Yes, thank you so much, everyone. It's a great series.